Hi, this is Kevin Baumer, CML Deputy Director, and welcome to the February 15th edition of the CML Statehouse Report. First off, we had a great legislative workshop yesterday over at History Colorado Museum. Had well over 100 of our members attend. The governor was kind enough to welcome us. There's a great shot of him on his way in, if you didn't see it, visiting with school kids. Sat down, took a picture of him. The looks on their faces priceless. It was a great moment. We also had some great sessions, and we're pleased to have Speaker of the House Casey Becker and Senate Minority Whip Ray Scott speak at the lunch. So a great event. Today, CML's Policy Committee met, and a lot of the legislation that we'll be talking about in today's Statehouse Report was considered by the Policy Committee. And next week, the CML board will take up the recommendations from the Policy Committee. So I'll jump right in. I'm going to talk about the Colorado Open Meetings Act first, bill that has been on the calendar and keeps getting laid over. It's House Bill 1087. This is the bill that is introduced, would require municipalities to publish online through a website. An unfunded mandate is introduced. I'm pleased to announce that the sponsors have agreed to some language that will change that legislation to more aspirational, more of a carrot, not a stick approach. And we thank the sponsors for working with us. Essentially, if a local government publishes their notices of their meeting online, in a manner prescribed by the bill, that be compliant with the Open Meetings Act, and will be no longer required to have a physical notice posted. So great incentive. We're going to put some language in there that mentions the Colorado State-wide Internet Portal Authority as a resource to our municipalities that don't yet have a website or content management in order to be doing this stuff. So we appreciate the sponsors, Representatives Soper and Hanson, for working with us on that. Moving to employment items, a lot of things are coming in the next several weeks. First bill that has been introduced, it's Senate Bill 85. This is the Equal Pay for Equal Work Act. It is sitting, waiting a hearing coming up in the Senate Judiciary Committee. Colorado is one of the only states, as I mentioned previously, that doesn't have a wage discrimination based on gender law, and so time is probably due for that, but some concerns with the introduced version of the bill that it doesn't parallel federal law, actually has some more extreme measures that working with the private sector employers, we've expressed some concerns and hope to see the sponsors deal with some of those to really make that an effective law similar to what we see in other states. That's Senate Bill 85 and currently opposed unless amended on that legislation. The Policy Committee did say if we're able to resolve all of our concerns, then we should move to a support position. So we'll deal with the issues first and then go from there. Staying with employment, two issues that have not been introduced yet, but we expect in the near future. First is dealing with local government minimum wage. Previous legislative efforts that would repeal the preemption on local governments from establishing their own local minimum wage, the league has been neutral on, because simply repealing existing preemption doesn't actually do anything. The only legislation that gave affirmative authority to local governments to exceed the statewide minimum wage as the Constitution requires would be appropriate, and we may actually see that in legislation now. We are waiting, though. We want to see what is actually introduced. We understand that while we may see that affirmative authority, we also may see language that says if a county establishes a minimum wage, that it applies county-wide within municipalities, whether a municipality wants it or not, and that's something we just can't support. So we hope to be able to support the legislation if it is purely local control of what occurs within municipalities and counties for the unincorporated areas. If that happens, we'll support the bill. Still remains to be seen. The other bill not yet introduced that is still going through discussions and iterations is a bill that will be introduced for the 5th year in a row. This is the Family and Medical Leave Insurance Bill. The bill has seen multiple iterations, but this most recent one will include something that the past 4 have not. What the bill does is it's intended to mimic the Family Medical Leave Act, but would apply to all employers, not just 50 and over, and would provide wage replacement for death in the family, illness, caretaking of a family member, etc. But would be a funded wage replacement. Funded how? By a premium from a payroll deduction, and this year's version requires employers to pay for half of that premium, whereas that has not been the case in the past. It's very concerning. This would be a significant unfunded mandate on local governments, and a lot of discussion about how to resolve that, as well as how local governments that already have programs in place to benefit employees in those types of situations, how that would interact with them. So we currently are opposed unless amended, but that's on the latest draft. We continue to have discussions, and we'll see how that plays out. So that we expect those to be introduced soon. Next week, we'll see a little action on sales tax, Senate Bill 131, which would establish a de minimis amount under which a retailer in the state of Colorado delivering to another jurisdiction in Colorado would be exempt from the sales taxes to statutory entities if under $100,000. This is something that the staff has discretion to support. We want to make sure all the amendments that are being proposed work, but it seems appropriate that small businesses with only a handful of deliveries to other jurisdictions could be exempt from that. Be clear, and everyone needs to be clear, it does not impact home rule municipalities with destination sourcing. That is completely separate. And that is Senate Bill 131. That's all the bills I have for this week.
Hi, this is Megan Dollar, Legislative and Policy Advocate with the Colorado Municipal League. This week I'm going to talk about two pieces of legislation that CML's worked on. The first one is House Bill 1009. The bill does several things, but the real piece in it that CML is following is a licensing program for sober living homes here in the state of Colorado. Municipalities are hoping the state can step in and look at some sort of regulatory option for sober living homes because individuals that reside in those sober living homes that may be addicted to substances or recovering are considered a protected class by the federal government. We're hoping the state can step in with the regulatory option so that they can be regulated without there being a concern that anyone is being discriminatory towards the individuals in those homes. In committee, the bill will likely be amended to remove the licensing piece for sober living homes, but what it will do is require that the operator of that sober living home meet a national standard, as well as some specific definitions and requirements that the state will lay out. CML needs to see if that amendment will be adopted and see if that amendment still, though it's softer than what's currently in the bill, will meet our needs in order to contemplate whether or not we are going to continue our support for the bill. The other piece of legislation is House Bill 1119. What this bill does is create a process for the public to access internal affairs files. CML has been working on this piece of legislation for the last couple of weeks. We've joined the Colorado Association of Chiefs of Police, the Sheriff's Association, the Fraternal Order of Police, and other stakeholders to meet with the proponents of the bill and talk about some of our concerns within the introduced version. The bill will be heard in House Judiciary next week on February 19th. We believe at that time the proponents will offer a strike below amendment that remedies the majority of CML's concerns, as well as the Colorado Association of Chiefs of Police. When that amendment is adopted, CML will go neutral on that piece of legislation.
Hello, this is Morgan Cullen. Another productive week down at the Capitol. I'm going to talk to you today about House Bill 1084. It's CML-initiated legislation that has to do with requiring municipalities to notify property owners of a blight designation. Currently, under state law, municipalities are required to notify property owners of a blight designation study. However, they're not required to do so if a blight designation has been determined. So this bill will expand the existing urban renewal statute to proactively require that of municipalities. And really, it's in response to a 10th Circuit Court of Appeals decision that was handed down last May that in Glendale versus Mack Investment Properties. And they ruled that municipalities have to do this, otherwise property owners' due process is essentially violated because they can't effectively repeal the decision. So our executive board has asked that we update the urban renewal statute to reflect this requirement and require municipalities to do so within 7 days. So bill passed on third reading in the House earlier this week unanimously, and we expect a similar result to happen in the Senate in about a week.
Hi,
Hi, my name is Brandy Delay. I'm a legislative and policy advocate here at the Colorado Municipal League. I have one update for today. If you've been following along, we have been focusing pretty heavily on House Bill 1086, which is our plumbing inspection bill. The current proposal on the table from the plumbing union and some other folks who are proposing the current legislation is requiring that there is a contemporaneous review piece as well as a continuing education piece for current plumbers. So really what this means for local governments is that if you are an inspector and you go on site, you need to ensure that all plumbers who are active at the time are properly licensed and or certified. And then secondarily, those folks who are plumbers will continue to get education through ICC or pursue their journeyman qualifications and certification. I would also suggest that we have a stakeholder process that I think we're going to try to identify throughout the summer, which will be mediated most likely with Majority Leader Garnett. During this process, we will talk about future legislation with the Plumbers Union on what journeyman licensure looks like, if that's necessary, and ultimately if there's a piece of legislation that we can compromise on. During this process, I do want to ensure that we have building officials who are part of that process, who are the subject matter experts that I am not. I will make sure to reach out to folks so that they can be a part of that process and so that they remain updated on what comes out of the stakeholder process. So I think ultimately the takeaway for today is we're waiting to hear and ensure that our friends in the Plumbers Union and the bill sponsor are willing to run with this amendment, which ultimately will put CML in a neutral spot. If you have questions, like always, feel free to reach out to me.
Thanks again for joining us this week. Look forward to having you join us next week for the February 22nd edition of the CML Statehouse Report.